The Supreme Court just handed down a bombshell ruling that is going to completely derail tens of thousands of active lawsuits across the United States. Yesterday, in a controversial 7-2 vote, the Supreme Court ruled in favor of the company Monsanto and their parent company, also effectively building a legal brick wall that shields not just their company but others as well from state-level cancer lawsuits. Now, if you spent any time watching TV or listening to the radio or just seeing things on the internet, you've probably seen the commercials saying things like if you have a loved one or someone else that use Roundup and they develop some sort of cancer, you may be entitled to financial compensation. And really, this is what this case involves. Billions of dollars have already been won by plaintiffs in front of state juries involving this issue. But yesterday, the Supreme Court in this 7-2 ruling essentially put an end to all of this. The core question that the Supreme Court had to answer was, can a state court jury punish a company for failing to put a cancer warning label on a product when the federal government explicitly tells a company that they're not allowed to put those warning labels on their product? This case is a massive clash between state tort laws and federal regulatory powers. And so in this video, we're going to be diving into this 7-2 ruling and what this means going forward. Now, before we jump into this video, if you like this type of content and you want to make sure that you get these types of videos going forward, make sure you like, comment, and also subscribe and turn on all notifications to ensure you never miss these types of videos when I release them. Now, to understand how we got to the Supreme Court in this case, we have to look at the individual here that's kind of at the center of this whole lawsuit. So you had an individual here, John Darnell, who was a Missouri gardener, and Darnell was using certain products, Monsanto's signature product, Roundup, which is part of a lot of lawsuits. And essentially, he used that product for over 20 years while he was managing weeds on his property. Now, in 2019, he was diagnosed with non-Hodgkin's lymphoma, which is a severe form of blood cancer. Now, believing his illness was directly tied to his decades use of using Roundup, he brought a lawsuit against Monsanto in a court in Missouri. Now, his primary legal argument was a classic product liability theory, which he brought here, which is simply a failure to warn. Darnell asserted that Monsanto knew about the potential cancer risks of Roundup, but chose to keep its customers in the dark by omitting a clear cancer warning label on the bottle. Now, in 2023, a Missouri state jury sided with Mr. Darnell and granted him an award of $1.25 million in damages. But after that ruling, Monsanto immediately appealed up to the Court of Appeals, pointing to federal preemption as an issue. You see, the scientific community has been sharply divided on Roundup and one of the chemicals, glyphosate. In 2015, the International Agency for Research on Cancer, an arm of the WHO, classified glyphosate as probably carcinogenic to humans. That classification is really what sparked the avalanche of thousands of lawsuits nationwide against the company. But on the other side, the EPA, which is again a federal agency in the United States, they repeatedly reviewed glyphosate for over 3 decades. Every single time, the EPA concluded that glyphosate is not likely to be carcinogenic to humans when used according to the label. Because the EPA determined it wasn't a carcinogen, the federal government explicitly banned Monsanto from putting a cancer warning label on Roundup, stating that it would be false and misleading. So Monsanto claims that they found themselves in a legal pickle. If they added the warning label to satisfy state laws, they argued that they would be violating federal laws. If they kept the warning label off to satisfy federal laws and the EPA's guidance on their label, well, then state juries were going to hit them with millions of dollars in damages in these lawsuits. Because of this, Monsanto argues that they had to take this challenge to the Supreme Court, relying on a constitutional doctrine known as express preemption. Under the Supremacy Clause of the Constitution, when federal law and state laws directly collide, the concept is that the federal law should win out. Monsanto argued that a federal statute from 1947 completely barred Darnell's current lawsuit. The FIFRA law here governs how pesticides are registered, sold, and labeled across the United States. Crucially, in this case, Section 137V, subsection B of FIFRA contains a uniformity clause, and that is what Monsanto is pointing to in this case. That section explicitly states that such state shall not impose or continue in effect any requirement for labeling or packaging in addition to or different from those required under this subchapter. And it is this legal landmine that the Supreme Court just weighed in this case and ruled in favor of the company in their 7-2 ruling. Justice Brett Kavanaugh, writing for the majority of the court, sees directly on this text in the subchapter. Kavanaugh explained that when the EPA approves a pesticide label, that label becomes the absolute federal standard. A manufacturer is legally obligated to use that exact label and cannot alter it without federal permission. Kavanaugh wrote that Darnell's state tort claim would require Monsanto to add a cancer warning to Roundup's labels, even though the federal law requires Monsanto to use the EPA-approved label without that type of warning. Because Darnell's state tort claim would impose a pesticide labeling requirement in addition to what the EPA already approved, they essentially said that this state law is invalid and it's preempted by the federal law. So in plain English, the court ruled that a state court lawsuit operates as a state requirement. If a jury verdict forces a company to change its label to avoid paying millions of dollars, the state jury is dictating labeling laws. And because that mandated warning is different from what the EPA requires, the lawsuit is unconstitutional under the federal law FIFRA. Now, what makes this decision incredibly fascinating from a legal standpoint is the ideological kind of breakdown of the Supreme Court. This wasn't kind of the standard 6-3 conservative versus liberal justices in that traditional split. The conservative Justice Brett Kavanaugh, like I mentioned, authored the majority. He was joined by Roberts, Alito, Amy Coney Barrett, Justice Thomas, and then also they were joined by the liberals Sonia Sotomayor and Kagan. But then you had a dissent, which was authored by Ketanji Brown Jackson, and she was actually joined by Justice Gorsuch. In the dissent, these two justices approached this issue from a completely different angle from the majority, arguing that the majority was giving federal agencies far too much protective power over companies. Jackson argued that under FIFRA, a pesticide is legally considered misbranded if the label fails to contain warnings that are adequate to protect human health. In her view, and also the view of Justice Gorsuch, a state-level lawsuit isn't creating a new law. It's simply a mechanism for an injured citizen to prove that the product was in fact unsafe and misbranded. The dissent pointed out that the EPA's registration of the product is only one baseline of evidence of safety, not an absolute immunity shield that can be put in place by the EPA. Jackson argued that there were alternative ways that Monsanto could have warned consumers without violating these federal regulations, and that stripping everyday citizens of their right to sue in state courts leaves families completely unprotected when federal oversight actually falls short. We also saw a fascinating solo concurrence from Justice Thomas. While he did vote with the majority to essentially protect the company here under the text of FIFRA, he issued a warning shot regarding the administrative state. Thomas questions whether Congress even has the constitutional authority under the Commerce Clause to dictate how a private citizen uses a weed killer in their own backyard, hinting at that he would want to revisit the scope of the federal environmental laws entirely, kind of wanting to look at them comprehensively going forward. Again, we've seen this in multiple cases where we have a concurrence from Thomas saying that he wants to look at the Commerce Clause once again. So what is the ultimate takeaway from this case, and who are the ultimate winners? Well, of course, the company won in this lawsuit. The Supreme Court ruled in their favor, saying that this type of lawsuit is barred. The Supreme Court ruling acts as a massive shield, effectively foreclosing the vast majority of current and potentially future warning-based lawsuits across the country against the company. Now, again, the biggest loser is the individual consumers and these individuals here. So this ruling heavily solidifies the power of the federal government and the agencies, essentially making the EPA, in their word, really the absolute law of the land when it comes to what is required on these labels. So let me know down in the comment section below your thoughts on this ruling. What do you think about the decision? Who do you think got it right? Do you agree with the majority, or do you agree with the dissenters in this case? So let me know down in the comment section your opinions on this ruling. If you want to get more updates on these types of cases and things that are going on, make sure you like, comment, subscribe, and also turn on all notifications to ensure you always get these videos when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.